Hi, good morning if you're out west, good afternoon if you're on the East Coast. This is Aaron Lacey at Thompson, Coburn, and you are tuning into our second in a three-part series on the ongoing bar defense rule negotiated rulemaking process, the 1718 negotiated rulemaking. And these are debriefing webinars. As some of you know, I'm a participant in the process representing general counsels, attorneys, and compliance officers from institutions of higher education. And we do webinars all the time on various topics relating to higher education. But in this case, we really specifically wanted to do a series of webinars for the purpose of debriefing that constituency. Of course, very happy for folks who may not fall into that constituency to be on nonetheless if you have an interest in what's going on. So just a little bit of information about me. Mentioned earlier, I'm a partner in the higher ed practice at Thompson Coburn. Just so that you know, and I know a lot of folks have attended these webinars before or know me, and I've had a chance to meet you elsewhere. But for the folks who haven't, our higher ed practice, I sort of divide it into three buckets. We do regulatory work for folks and help guide them in their dealings with all the different state, federal, and accrediting agency laws and standards that relate to higher ed. We assist institutions of all stripes with transactions of all types, whether that be a sale or a joint venture or some sort of negotiation or contracting with a vendor. Also do lots of policy design and creation, help folks with all different kinds of things. And then finally, we do represent institutions in various different capacities, whether that be in administrative proceedings or in a proceeding with the U.S. Department of Education. I personally do a lot of that work, or with an accreditor or some other entity with which they may be having an issue. So that you know, before I was here with the law firm, I spent some time in-house working with an institution and managing their regulatory and government affairs. And prior to that, spent about a decade, almost a decade, maybe not that much, about 8 years in Washington, D.C. with another law firm in their higher education practice. So I've done this my entire career and consider higher ed very much my home. Mentioned that earlier, that I'm one of the negotiators involved in this process, and that was one of the reasons we really wanted to make sure to conduct some outreach. So here's the outline. Some of this, if you attended the first session, you will have heard before. My promise to you is I'm not going to go through all of that again in the same level of detail. And with that said, if you are someone who feels like you want a little more background regarding the bar defense process to date and the 2016 negotiated rulemaking and the history, you are very welcome to go back and listen to that first webinar. It is available on our website, free and on demand. I do want, though, to provide everybody with some context. I think it's very useful when you're leading up to the more detailed discussion to remind ourselves sort of where we came from. So we're going to talk about the bar defense origin story, and then I'll talk about what I call BDR2, which was the rulemaking that occurred last year. But then, as you would expect, the bulk of our time will be spent on BDR3. So I'm going to bring you up to speed on this year's negotiated rulemaking, talk a little bit about the last session, and then really spend the bulk of the time here, and I've got it in red, on session 2 for the current round of rulemaking. Now, I'm going to pause just briefly, otherwise my producer is going to start throwing things at me, and make sure I hit all the housekeeping. So this program is CLE certified. That's continuing legal education. So if you're an attorney out there and you're looking to pick up CLE, you can do it. Certificates will be sent the days following the webinar. Please remember that for CLE credit, you have to log in with the same email address you used to register for the webinar. That login is proof of attendance and supports our awarding of the CLE to you. If you need to leave the webinar, you should log out and then log back in when you return. If you are seeking CLE credit, you'll also need to verify your attendance. During this webinar, you will see 3 top secret code words. I will make sure to point them out to you. You should write them down because you may need to provide them on the verification form when you're looking to qualify your CLE. If you have any questions, you can reach out to me and I can give you a contact relating to CLE, and how to get your CLE taken care of. This webinar is timed to last approximately 90 minutes, and I've attempted to build in some time for questions. I'll respond to questions at the end of the webinar, but you can ask a question at any time. In order to do so, just open that chat box by clicking on the chat bubble in the top right-hand section of your screen. The webinar, like all the webinars in this series of 3, is being recorded and will be available free and on demand on our website We always aim for approximately 10 days. We have a Q&A process. Sometimes it takes a little bit longer. Sometimes it takes a little less. If for some reason you can't locate the recorded webinar after 10 days have gone by, don't hesitate to reach out to us, and we'll see what we can do. Also, and this is very important, please remember that if you are listening to this webinar at some time after the original air date, it is very possible that law and guidance has changed. For that matter, I mean, I'm giving you an update on an ongoing process. We've just finished round 2, so if you're listening to this for some reason 6 months from now, keep in mind that there has probably already been significant development since the time that this webinar originally aired. Finally, an electronic survey form will be sent following the webinar, and we deeply appreciate folks taking the time to fill in the form and return it to us. We really do pay attention to the comments, and we try to make each subsequent webinar better than the one before. By the way, the other thing I will mention, and this is a place where I sometimes fail to keep up with the comments, we will circulate and everyone will receive this deck who even registered for the webinar, even if you weren't able to attend today. And my deep apologies for not having the time to get the deck out to you in advance. I was working on it up until just a few hours ago, so that's why you didn't get it, but you will get a copy. All right, so the bar defense origin story, and this is really what we're focused on today, right? And this whole rulemaking we're going through is about this concept. So in '93, the Congress created the direct loan program, as a lot of people know, to compete with FFEL, and now everything is direct loan. As part of that legislation, Congress directed the U.S. Department of Education to, quote, specify in regulations which acts or omissions of an institution of higher education a borrower could assert as a defense to repayment of a loan made under this part, meaning a direct loan. So the idea here is if the Department of Education is trying to collect on a loan that a borrower took out to go to school somewhere, and the borrower could say, wait a minute, I shouldn't have to repay this loan, i.e. assert a defense in the context of that proceeding, because my institution did X or Y or Z while I was enrolled. And whatever that was, it's grounds for me not having to pay back that loan. So that's the whole idea that we're really getting into. Shortly thereafter, the department introduced in the regulations, and you can see the citation there, a basic framework, and that framework is more or less still in place today. And I'll talk a little bit more about that later on. But as of right now, this is still fundamentally the framework that governs. And the idea is the department would initiate a collection proceeding, and then a borrower would assert a defense, whatever they're saying that their institution did, and the department would consider that defense. And if they felt like it was appropriate, they would discharge the student's loans, and then they would have 3 years to turn around and recover that amount discharged from the institution that committed the act or omission. If this is your first time to this concept, then you can understand why this is such an important issue for institutions, because the idea is the institutions are on the hook for those amounts discharged, and the department has made clear repeatedly, including in the context of the current negotiation, that they will pursue institutions to recover on these discharge loans and feel like they have an obligation to the taxpayer to do so. All right. So I will add here, and though it's not reflected in my presentation, very recently the department offered up some guidance as to how they're still operating under this law and this basic framework, but it's been augmented slightly, not in the regulations, but just at the sub-regulatory level, to allow borrowers to essentially file an application without having to be in the midst of a collection proceeding. And the department recently has put out guidance as to how they're attempting to streamline and address a backlog of existing borrower defense claims. So, but jumping back to our origin story, so a borrower defense included, quote, any act or omission of the school that attended by the student that would give rise to a cause of action against the school under applicable state law. Right. So, in other words, if a borrower, under the original regulations, what the department said is if a borrower wants to assert a defense, what they have to do is say that the school did something that basically would have broken a state law, right? And presumably the state, either of their residence or where the school was located. Although, part of the reason the department is trying to redo all of this is because it has turned out that this is a very cumbersome standard for the department to attempt to implement, right? Because it puts the department in the position of, first of all, trying to figure out what state law would apply, and that can get particularly squirrely if you've got an online institution with residents all over the country, even the world. But then secondarily, the department has to try to figure out which state laws are implicated and make a determination as to whether the act or omission would have violated that state law. And the department has said in the context of this rulemaking and previously that that is an extremely challenging thing for them to do. In 1995 Notice of Interpretation, the department added a little additional context. One of the things they specified is that cause of action under state law has to relate to the loan or the school's provisions of educational services. So it can't just be anything the school did that would give rise to an action under any state law. And they offered some examples of the types of state law violations that would not be applicable here. At the time, they said personal injury tort claims, actions based on allegations of sexual or racial harassment, for example, would be excluded. With regard to timing, you know, these statute of limitations concepts are always really important when you're talking about when somebody can bring a claim in any context. So under the law that still prevails, right, that was put out back in 95 in those or in 93 actually in those regulations, the department said, look, a borrower can assert a defense at any time without regard to when the underlying act or omission occurred. But the department only had 3 years from the borrower's last award year to initiate a proceeding to recover those funds from the school. The obvious problem, and it's interesting to me that nobody thought of this back at the time the department offered up this guidance, but the clear problem this creates is it creates exposure for the taxpayer, right? Because you could have a situation where a borrower could seek to discharge their loan, say, 10 years after the act or omission occurred, but the department can no longer turn around and try to recover. And of course, that just means that if the loan is in fact discharged, that the taxpayer absorbs that. The department is well aware at this point of this issue, and we're going to talk about this later, is trying to revise the various timing of the statute of limitations to make sure that that doesn't occur. So there was no discussion of the process that the department would follow back in 95 when it put out that additional guidance, but the department did acknowledge that schools are entitled to due process in these proceedings. Right? So important point, prior to 2015, the department only received 5, and you'll see, I think on this slide it says DTR. Typically I refer to it as a BDR, Borrower Defense to Repayment claim. But the department had only received 5 claims over the course of 20 years. And then as of June 24th, 2016, there were, many people know, a couple of very large school failures, and as a consequence, there were many of these applications suddenly filed and folks asserting these defenses. And as of June 24, 2016, 26,603 bar defense claims have been filed and 73 million discharged, with an additional 97 million in closed school discharges. As of August 15, 2017, the department reported north of 98,000 bar defense claims filed, and that number has been slowly ticking up since that date. So you can see why the department had to go back to the drawing board. For a 20-year period, they had essentially no reason to be concerned with this regulation, and then all of a sudden they had literally tens of thousands of claims being filed and really no developed process with which to manage these claims. Also note here, 89% of those claims as of August 15, 2017, related to 4 schools, including primarily the large institutions that had failed. But we are seeing a widening of the institutions as time goes by for which bar defense claims have been filed. Nothing on the order of the tens of thousands, but there are slowly more and more institutions from all sectors against which bar defense claims are being filed. Okay, so BDR2, negotiated rulemaking. So you had this period of 20-plus years during which the original regulation and that little bit of 95 guidance was in place, and then you had this sort of explosion of bar defense claims. So the department announced that it was going to start a negotiated rulemaking, and that was about 18 months ago, and that was what I'm referring to in the context of this presentation as BDR2. By the way, here's your first secret word. It is Bacchus. The first secret word is Bacchus. Okay, so in October 2015, the department announced their intent to revise these negotiated rulemaking concepts. And so that you know, and I went into a little more detail in this in session 1 or in the first webinar in this series, but if you're not familiar with negotiated rulemaking, it's the process by which the department develops its regulations, and it is required to do so under the law, in collaboration with representatives of groups who will be affected significantly by the rule. So they literally reach out and pull together 18 or 19 people, usually around there, and each one of those persons represents a different constituency. I mentioned earlier I'm representing attorneys and compliance officers from institutions. There are folks there representing state agencies, accreditors, consumer advocacy groups, guarantee agencies, financial aid professionals, etc. They have typically a series of meetings. Usually it's 3, occasionally it's 4. Each one is usually 3 or 4 days long, and they're in D.C. And they get all those people together and they sit them around a table, and then they talk about these rules. And the department offers up its thinking, and folks negotiate what they believe should be the final product. The hope is that everyone will come to consensus, and that is a unanimous agreement by all parties at the table with regard to the language for the new rule. If consensus is achieved, the department commits to using that regulatory language. If it's not achieved, the department can elect to terminate the rulemaking, use regulatory language developed during the negotiations, or develop totally new regulatory language. Typically, what you would see as you go through this process is if there's not consensus, and in recent years there have been a handful of rulemakings where there was not consensus, you would typically see something that probably looked like the draft language the department had proposed during the sessions, augmented either where there was consensus on certain elements of the language and also including the department's own views. Now, I just want to make clear, consensus has to be achieved on the entire regulation for the department to be bound. But as you're going through this process, there will be, many sort of thumbs up, thumbs downs on specific changes or revisions, and the department's keeping track of those, right? So if everyone is in agreement at the table on certain revisions, the department's not bound to take them, but when it goes back, even if consensus on the whole rule isn't reached, when it goes back to develop the proposed rule, there's an expectation, and it is frequently the case that they will take many of those suggestions in hand. Also, just looking forward, what will happen after the negotiated rulemaking sessions are over is the department will sort of go back. If we have consensus, it would take the rule as agreed to. If it doesn't, if we don't, then it will take and come up with its own rule, taking into account, the negotiated rulemaking. It'll put out a proposed rule, and then there will be a period, typically over the summer, during which folks can comment, and then the department will come back with a final rule, which it has to publish by November 1st of this year if it wants the rule to be effective as of July 1 next year, and that also is in the regulation and the law. Okay, so the topics on the table for the Bar Defense 2, this was the negotiated rulemaking that took place last year, included not just this fundamental bar defense concept, but also there were some other ideas included. I'm not going to go into great detail here. We've got other sessions on our website, webinars in the past where we went into all of this ad nauseum. But it's important to note that while the headliner here is this bar defense framework, and that is what I'm going to spend most of the day talking about, there were a lot of other issues that got wrapped in, and this year also are on the table. Notions regarding institutional financial responsibility, whether or not institutions should be allowed to include pre-dispute arbitration agreements or class action waivers in agreements with students, revisions to the closed school discharge and false certification discharge provisions. And then in 2016, last year, there was also discussion around revising the existing definition of misrepresentation in federal law, which doesn't relate specifically to bar defense, but there is a definition of misrepresentation already there, which during the 2016 rulemaking, the department looked to incorporate into the bar defense framework. And then finally, there was a concept around some new repayment rates that was specifically for proprietary schools. This raises another point that's important to make. This framework and the issues on the table for bar defense rulemaking applies to all institutions. The only place where that's not the case is if, for example, the department has a specific provision somewhere talking about how publicly traded institutions should be treated in a particular circumstance, or something like that. But the vast majority of this, and certainly the bar defense concept proper, applies to all institutions of higher ed. Okay, so thinking about, we talked about the origin story, and I gave you a general idea how it worked as of 1995. So this is what was proposed last year, and I just want to walk quickly through this, and you're going to see a new version of this in a few minutes when I start talking about the current round of negotiated rulemaking. So, and it's important when you think about these frameworks to try to get your mind around what sort of the core pieces are that are in play and how they relate to one another, right? And that's what this is setting out. So last year in the 2016 rulemaking, the department proposed what was essentially a new framework for what would constitute a bar defense claim and the process by which those claims would be resolved. there was no collection action required. So in other words, the department said we don't have to initiate a collection proceeding from a borrower and require them to assert a defense. In other words, someone who feels like they would have a bar defense claim can simply put forth an application. I think there's a very legitimate question as to whether or not that is consistent with the statutory language, but it seems in some respects that ship has sailed. Certainly the department, both last year and in the context of this year's negotiated rulemaking, feels that no collection action should be required. And you know, you can understand the public policy argument there. We shouldn't require students to go into default to be able to assert a bar defense claim if they believe they have a valid claim. At least that would be the argument. There was a new federal standard that was proposed last year in 2016, and it broke down into several parts. But the salient point there is, and I mentioned earlier, the department felt like the existing standard, which required them to interpret state law and to figure out which state law is applied, was extremely cumbersome. And they felt like it would be more appropriate for them to establish a federal standard that borrowers could cite and that they could administer directly. There were new time limitations placed on when borrowers could assert a claim. Interestingly enough, under the original rule I mentioned earlier, there was no limitation on when a borrower could bring a claim. There were also new time limitations on recovery actions, and that's the department trying to recover the funds that have been discharged from an institution. There was a new individual claim process that was put forth, and really prior to that, there had been no meaningful process articulated in the law. You'll recall a prior slide where I said, you know, the department acknowledged that schools were entitled to due process, but didn't articulate how that process of adjudicating a claim would work. There was also a group claim process introduced last year, which would have permitted the department unilaterally to bring a bar defense claim or essentially seek to discharge loans for a group of borrowers even in the absence of any actual claims having been filed. Again, sort of raising questions as to how that squares with the statutory language. And then the department last year went into some detail anyway, regarding how relief would be determined and proposed various different ideas for calculating relief. And that was sort of the framework as a whole, and all those pieces work together, right? Okay, so now I want to talk, oh, here's your secret word, your second secret word. It is Zulu. Now we're going to go to BDR3, which is the current round of negotiated rulemaking, and a timeline. All right, so when you look at this chart, here you see on the left we've got dates, and on the right we've got events relating to the Bar Defense Rule Odyssey. The red line is inauguration day, right? So everything above the red line between October 2015 and January 19th, 2017, that was the BDR2 process, okay? And the regs that were promulgated November 1st, 2016 were set to become effective this year on July 1st. Now, an important side note, on January 19th, 2017, the department published procedural rules that would govern the process by which the department would seek to recover funds that had been discharged from institutions. Those regulations went into effect immediately because they were deemed to be procedural. And the current administration acknowledges that those regulations continue to be in effect. Now, in the last session, the question was raised, and they confirmed that we could augment those regulations if, as a consequence of some of the deliberations going on right now, we determined that there was a change to those regs that needed to be made. But it's really important to note that while the 2016 regulations have effectively been, or the regulations that were negotiated last year, promulgated last November 1st, have effectively been suspended at this point, the regulations governing the process by which the department would recover funds from institutions and that were promulgated on January 19th, 2017 remain in effect, right? Okay, so then you had Inauguration Day, and then I've highlighted the only real block I want to focus on, and that's June 16th, 2017. So this is the new administration. The department announced a, quote, indefinite delay of almost all elements of BDR2 pending resolution of litigation that had been filed by the California Association of Private Post-Secondary Schools. The department's intent to initiate a new rulemaking to overhaul BDR2 and public hearings to discuss an agenda for the BDR3 rulemaking. So they've moved forward, and that's what we're doing right now. This is the BDR3 negotiated rulemaking, and there have been other announcements in the interim that have essentially left the BDR2 2 version of the regulations in limbo, at least until July 1, 2018, and it appears to me that there is a likelihood that they will be delayed or their implementation will be delayed until July 1, 2019, which is the same date on which the BDR 3 regs that are being negotiated right now would become effective. So, you know, after everyone is running around the table and the dust is settled, what would basically happen is the BDR 2 regs that were negotiated in 2016 would never become effective, but for those procedural regulations that were promulgated January 19, 2017. Okay, so now you've sort of got all the backstory, complicated as it is, and you are very welcome to look at these slides in more detail that we've already gone through if you feel like you want to think back through all of that. But I want to get on now to BDR 3, which is the current negotiations that are happening, and to really talk with you all about what the department has proposed and what they're thinking and what's on the table. So the first session occurred in November, and we did have a webinar following that. Again, you're all welcome to go back and listen to that if you weren't able to previously. But the couple of points I wanted to remind folks of from that first session. The first is that the department made very clear that we're starting from scratch, okay? So they said in other words, we're not taking the 2016 version and doing a markup. We're basically ignoring the 2016 negotiations, and we are taking the statute and regulations that were in effect prior to 2016, and that's what we're working from, right? But those were a couple of points. First of all, that statute and those regulations are so bare bones that what it really means is we are inventing a lot of things, right? There's not a lot to mark up. I mean, almost all of it is brand new, okay? The other thing is the 2016 regulations have not been excluded from the negotiations and the conversation. I mean, it's really impossible to do that, right? You've got 17 people around the table, some of whom were actually involved in those negotiations, many of whom have reviewed them and reviewed the guidance that went along with them. And I'm not suggesting that negotiators, there are a few, but for the most part, it's not that people are making a concerted effort to bring up the 2016 version. It's just impossible to ignore. I mean, that all happened, and many of us at the table are aware that it happened, right? So that context is there, and there's nothing we can do about that, whether we wanted to or not. Okay, so the other point I wanted to make is that there are more topics on the table than just the sort of core framework for how to resolve borrower defense claims. Of course, that is the headliner, both whether there should be sort of a new federal claim standard and what the process would look like for discharge and recovery actions. But once again, we've got other things on the table. We are looking at the financial responsibility and administrative capability regulations, and particularly how they relate to risks that might be created by high numbers of borrower defense claims. But still, we're looking at those regulations a little more broadly than just borrower defense. There is, again, some discussion of pre-dispute arbitration agreements and class action waivers, as well as internal dispute processes. There are modifications to the closed school discharge regulations that have been proposed, as well as to false certification discharge regulations. There is a financial responsibility subcommittee that is tasked with trying to figure out how to revise the composite score calculations for both nonprofit and for-profit institutions to account for FASB changes in the accounting rules that have occurred in the last, I think, 3 to 4 years. I know that they were previewed some time ago and that the changes have actually occurred more recently. But the composite score language in the regulations has not been updated, I believe, in something like 2 decades. And then there are a couple of other issues, one relating to guarantee agency collection fees around borrowers and claims, borrower defense claims where amounts may be, where collection activity may be paused, if there's a pending borrower defense claim, or if there's a discharge, or if there's been a consolidation. There are some technical questions about how to manage collection fees, as well as the recalculation of borrower's subsidized usage period and interest accrual. I am not going to get into the collection fees and usage period and interest accrual questions. Those are, one, fairly technical, but also issues that are better spoken to by the guarantee agencies and financial aid reps and lending groups that are represented around the table. Everything else, though, we're going to hit on. So session 2. This is the session that met in January, and we met for 4 days. And I won't say just prior, but about a week and a half prior to meeting, the department released draft language. I want to be really clear because I know sometimes it can get confusing. During the course of the negotiated rulemaking, the department will release what I will call draft regs for the consideration of the negotiators. That is distinct from the proposed regulations that the Department will put forth in the Federal Register subsequent to the conclusion of the negotiated rulemaking, right? So we have seen actual draft regulatory language. We're not just dealing with concepts. Like I said, about a week and a half, 2 weeks before the last round, we got to see that language, and that's what I'm going to walk you through today. But I've tried to very carefully label it here as draft language because it's very much in play, and sometimes it can change fairly significantly between even the second and third round of the negotiations, and certainly it could be changed dramatically or completely, in theory, and look very different from the proposed regs that the Department puts out. Of course, then there's a comment period, and you have the final regs. So we still got various iterations. That having been said, it is a big jump. When we did our prior webinar, all we had really done during the first session of the negotiated rulemaking was to focus on concepts. And now we have concrete regulatory language that has been put forth by the Department. And during the last session, the 4-day session, we were literally going through line by line these proposed regulations and hashing out the different concepts in the regs. And that's what I'm going to put in front of you today. So once again, the Department for Borrower Defense has proposed a framework, right? And that includes both standards and process. And sort of like that prior slide right here, I wanted to give you an overview of the primary components. And it's really important to keep in mind that all of this works together and sort of balances together. And in fact, I will just observe, I think one of the great challenges that the negotiators are having in moving towards consensus, and I mean everybody, I can't speak for anyone but myself, but I also don't mean to suggest that this is a challenge only experienced by one group or another. One of the great challenges is when you move through these regs line by line, the draft regs, and you're looking at concepts in isolation, it is easy to say, well, this particular standard or this particular concept seems either too weak or too strong or problematic for me. But when you're talking about a legal standard and process like this, so you're talking about definitions and burdens of proof and what represents a claim and how that claim will be, adjudicated, it all hangs together. I mean, it's designed by the Department so that while a definition, for example, might be a little weak, on one hand, the burden of proof on the other hand might be stronger, right? Or different elements that may be required to state a claim. In some cases, it may require more evidence. In some cases, it may require less. And, the Department has articulated, and I think it is very true, that they are attempting to achieve a balance here, right? But it is a challenge for the negotiators, I will just let you all know, because we're often being asked not to think of this whole thing as a whole, because it's very hard to sort of comment on the whole thing as a whole, but instead, practically speaking, to go through it in its components. The problem is you get burdened down or bogged down on one component, and no one wants to necessarily give any ground, or they may feel that it's very problematic because they have a concern that some other component might change, right? And if you agree to moving your position on one component, then you have a concern later on if the position moves on the other component. Now there's been a significant shift, right? So it's a really challenging process, but it is important to understand that all of these ideas do hang together and to think of them as hanging together and try to understand how they relate to one another. Okay, so I mentioned earlier, I think the train has somewhat left the station, certainly in the Department's mind, with regard to whether or not a student would have to actually assert, there would have to be a collection action that would precede the assertion of the defense. Even though I think the statute pretty clearly contemplates that, for a variety of reasons, I think the Department is taking the view that students should be able to file an application. That having been said, I think the Department is also acknowledging that if all a student has to do is file an application, that represents a pretty low barrier to entry, right? And the institutional representatives at the table certainly have articulated this point. When you talk about litigation, right, a student or employee or member of the public or vendor, whoever, suing a school, frivolous claims to some extent are deterred by the fact that filing a claim in court takes some effort and money, right? But filling out an application and submitting it, really other than identifying the application and figuring out how to submit it to the Department, say via email or mail, et cetera, there's virtually no barrier to entry. And so again, you get back to that balancing act. I think the Department understands here that there is, and I don't speak for the Department, this is just my personal observation, but my observation is that the Department seems to understand that there's a very low barrier to entry, and that's why it's important to balance that fact against evidentiary standards and burdens of proof and things along those lines. So there's no collection action required. There is a new federal standard for BDR claims. There are some folks at the table, interestingly enough, a couple of the attorney generals who have suggested that maybe there shouldn't be a federal standard, and this really should be something managed exclusively by the states. But the department has indeed proposed a federal standard. In this case, it involves a judgment, and what I'm calling a BDR misrepresentation. And the reason I've put BDR in front of that, capital letters, is because they are proposing a new concept of misrepresentation that is distinct from the definition of misrepresentation that exists elsewhere in federal law. So in 2016, the prior administration looked to use that existing definition and incorporate it into this framework. This administration has determined instead to come up with a new definition of misrepresentation. So that's a really important point. They've offered definitions of key terms, one, of course, being this new BDR misrepresentation, and also financial harm. And as you'll see in a minute, one of the things that is being proposed is that in order to state a claim on its face, a borrower has to establish that whatever the misrepresentation or basis for the claim was, it caused them some level of financial harm. And so the department has attempted to define what exactly that means. There's something I sort of jokingly call the borrower defense. The department has identified some specific types of evidence that an institution could advance to rebut certain types of BDR claims. So in other words, this is the institution's defense to the claim, borrower defense claim, being made by the borrower. There is a new time limitation on asserting a claim, which is a little different from what we saw in 2016 and different from the existing law. There's no limitation right now on recovery actions, although we talked about that. And then there is a new individual claim process. Remember, if we're disregarding 2016, which we are, we've been instructed to do that, there is no process right now then in the regs for how to discharge a borrower's claim. Although, once again, there is a process in the regs promulgated last January for how the department would recover against a school if amounts were discharged. The last thing I want to point out, you'll see a little asterisk at the end of the title here, and then if you look at the bottom in text, it says for BDR claims relating to loans first dispersed on or after July 1, 2019. So the earliest these regulations could go into effect is July 1, 2019, right? That's assuming that the final regs are promulgated this November 1, which means that these regulations and the changes, for the most part, would only apply to loans that were made or dispersed, I should say, after that point, right? Any loans that are dispersed prior to July 1, 2019 are going to be managed under current law, right? So, and the department has offered up a couple of very small tweaks to that language and that process. I'm not covering that here. What I'm really focused on is what they're proposing will be the new framework after these regulations become effective. The only tweak that they've really suggested in the law for loans dispersed prior to July 1, 2019 is that the department has removed that limitation on them that they can only bring an action 3 years after the borrower graduated. Remember, that's in current law. It says the borrower can bring their claim any time, but the department can only seek to recover from an institution up to 3 years after. And the reason was, I'm paraphrasing, but the idea there was institutions aren't required to keep financial aid and other records by the department more than 3 years, in most cases from when the borrower left the school or graduated. And so originally there was a sense that, well, it's not fair for us to try to recover from institutions if they don't have any records to defend themselves. I think that the new thinking is, you know what, institutions are keeping those records anyway. They understand they may have exposure. I'm not suggesting this is or is not true, but I think this is the thinking. And more importantly, we've got to protect the federal fisc. And, you know, we've got 90,000 borrower defense claims out there, and if we end up discharging millions and millions of dollars of loans, we can't limit our ability to try to recover from institutions, potentially. So the department is proposing to strike that language with these regulations. But everything I'm going to be talking about here and on the slides going forward is the new process they are proposing that would apply to loans first dispersed on or after July 1, 2019. Okay, so I want to break down those different things that I laid out on that prior slide. First, let's talk about the standard for claims. So, you know, what is the department really proposing would represent a borrower defense claim? First of all, they've incorporated that guidance from 1995, and we saw this in the 2016 negotiated rulemakings. Again, a borrower defense would involve an act or omission of a school at which the borrower enrolled that relates to 1, the making of the loan, or 2, the educational services for which the loan was made. Now, several of us at the table, myself included, suggested that the department needs to put more of a box around educational services, because that is not what that constitutes is not self-evident, and we thought it would be helpful both institutions and borrowers and all parties involved that there was a little bit better sense as to what exactly educational services, what was in and outside that scope. And I'm going to show you on another slide here. I mean, the department has made an effort to put a little bit of a box around it, but we've suggested that more of a box would be helpful for everyone so that, you know, people aren't wasting their time bringing claims that don't qualify. And we thought it was very important that that be done here on the front end because this is such a fundamental component of what's required to be a bar defense claim. The department did say, though, and I mentioned the box, that's the second bullet, in the reg they have stated, and this does not exist in current law, that excluded from bar defense, the sort of bar defense claim category would be HEA violations that are not otherwise BDR claims. What I mean by that. So if you have a technical violation, you have a late R2T4, that would not give rise to a bar defense claim, right? I mean, for a number of reasons, but there would be no potential financial damage or anything like that. But even beyond that, what the department is saying is, look, we do have some provisions in the law. For example, and I mentioned this earlier, you know, the department prohibits misrepresentation to students, totally apart from bar defense claim and this whole framework. There's separate law that just says you can't make a misrepresentation. So if you misrepresent something to students, it would be an HEA violation, right? I mean, if it is determined that that actually happened, it would be an HEA violation. And what the department is saying is, well, in that case, that's an HEA violation, but it would still qualify because it is otherwise also a BDR claim, or likely otherwise a BDR claim, right? And we'll go through that in a little more detail later. But what they're saying is, if it's a technical HEA violation, you know, you didn't calculate your crime statistics correctly, your copyright policy doesn't look quite right, you know, late R2T4 calculation, late credit balance, whatever you want to say, if it's not otherwise a BDR claim, the sheer fact that you violated the HEA is excluded. It's outside of this picture. In addition, personal injury claims, sexual harassment claims, civil rights violations, slander, defamation, property damage, educational malpractice, academic disputes, and disciplinary matters, the department has indicated are all excluded. Now, we talked a little bit because there were some folks at the table who were concerned that you could have a situation where a claim in part was an educational malpractice claim and in part might also involve what would qualify as a bar defense claim. And I think the department's view in that case is, well, then we would be looking to parse that out. You know, someone who has a valid bar defense claim, an institution can't just say, well, it's also theoretically an educational malpractice claim, so it doesn't qualify. I mean, I think the department understood that. But the department also is suggesting, and we certainly agreed, that there are many claims that are classic education malpractice claims, which basically means, you know, we don't think the school did a good job teaching us, right? I mean, that's sort of the simplified idea there. And the department is saying, look, just because you didn't like your courses or you didn't feel like the school did a good enough job teaching you, that does not give rise to a bar defense claim. That's an education malpractice claim. For loans dispersed on or after July 1st, 2019, and assuming that you had some act or omission that related either to the loan or the educational services provided, the department will discharge a borrower's loans and will refund the amounts paid on the loan in whole or in part, less any amounts already refunded to the borrower from any source, if the borrower established by clear and convincing evidence that they have a judgment of a court, a judgment of an arbitrator or administrative tribunal, or a BDR misrepresentation. Now, there is a lot to unpack here, and I'm about to go through some of this in greater detail. But just on this page, there are 2 or 3 things I want to comment on. The first thing is to note, and you'll see I have it in red, or in part. There was conversation among the negotiators and those who felt very strongly that the department should not grant partial relief, but it should always be full relief. But the department has maintained, for a variety of reasons, that it has the discretion and should have the discretion to grant partial relief. And in fact, that was the case last year in the 2016 negotiations as well. It's always been the case, and they don't seem to be backing down on that. I think institutional folks and most of the negotiators at the table, although, again, I don't speak for anyone but myself, but my observation is there is quite a bit of agreement that partial relief is appropriate and desirable. Less any amounts already refunded to the borrower from any source. So it's important to note, in case folks were wondering, the bar defense regulations historically have already do, and this is also the case with other types of discharge regs, and the department is proposing here would also include an offset provision to prevent double dipping. So in other words, if a borrower files a claim with a state tuition recovery fund, right, let's say they took out $20,000 in loans, spent $30,000 on their education, and they get $30,000 from some sort of tuition recovery fund, you know, the department says, well, in that case, if you then file a borrower defense claim, right, you're not going to be able to discharge that $20,000. In fact, what the law provides is that the department, if there actually is a discharge granted, then the Department of Education has a right to that $20,000 that the student got from the tuition recovery fund, right? So in other words, if they file that discharge and the department says, yeah, you're right, the loans were eligible for discharge, and the student has to, that $20,000 goes to the department, right? So that the student doesn't get to discharge their loans and keep the $20,000 out of the tuition recovery fund. Similarly, if a student sued you in state or federal court or otherwise got some sort of judgment against an institution and recovered their tuition, same thing would apply. If they then sought to discharge their loans, I mean, the department could grant the discharge, but if it does that, at the same time, the student agrees per the application that the department has a claim to that $20,000 they got from the judgment. So there are provisions here, and it's just important to note to prevent against double dipping. The other really important thing to note here is that the department is placing in this process upon the borrower an obligation to establish their claim by clear and convincing evidence. So those of you who are attorneys will have familiarity with the preponderance of the evidence standard, which and part of the, so let me take a step back. So there are various different kinds of standards by which decisions can be made that are typically in law, and people hear these in, you know, court drama movies and TV shows. One is the preponderance of the evidence standard. Another is clear and convincing, and then there's sort of the beyond a reasonable doubt standard that's common in criminal trials, right? And each of those standards requires, in theory, a higher level of proof. So in other words, whoever's bringing the claim, they have to provide a higher level of evidence, and the tribunal making the decision has to have a higher degree of confidence that that evidence substantiates the claim, right? In 2016, the department at that time was comfortable with and proposed a preponderance of the evidence standard, and which can be defined a lot of different ways, but often is defined more likely than not. I've heard it defined as 51%, but it basically means if there's a toss-up and the trier, the tribunal thinks it is, you know, 1 degree more likely than not, that's a preponderance of the evidence. Clear and convincing suggests something higher. How much higher is hard to say. You know, I've heard people say, well, if preponderance of the evidence is 51%, then clear and convincing is, you know, 65 to 85 or something like that. And then beyond a reasonable doubt is, you know, 99%, 100%, et cetera. I mean, it's a very high standard, which would not, most agree, I think, would not be appropriate in this context. So there was great debate among the negotiators as to whether or not this clear and convincing evidence standard was an appropriate standard here. And there are lots of arguments to be made as to why it may be or may not be. There were many people at the table, negotiators who are not lawyers, who were very uncomfortable using a legal standard when the department in this case is not bound by any sort of legal precedent, and many noted, you know, the department ultimately is going to have internal direction, and it's hard to know exactly what that internal direction is going to say. There's also a question as to whether or not the staff member at the department who's adjudicating one of these claims will be a lawyer or have any sense as to what the sort of legal history is around clear and convincing, or for that matter, preponderance of the evidence, et cetera. So there was great debate around this concept, whether it was appropriate to have a legal concept, whether this was the right legal concept, but it is the one the department has proposed. I mean, our view, my view, I should say, again, I only speak for myself, as an institutional representative, is I believe it is appropriate, and here is why, because the barrier to entry is so low. And that gets back to this idea of this being a balancing act, right? I mean, there are those who have argued, and certainly there is some validity to this, that in some civil proceedings, in some states, even in unfair deceptive Trade Practices Act or another type of misrepresentation or fraud claim, you might see a preponderance of the evidence standard. But those proceedings are different, right? It's a different context. You have a court proceeding, and there is a barrier to entry there just to get into that proceeding that acts to dissuade frivolous claims. Here, again, there's no barrier to entry. So I think the idea was, and I think the reason the department proposed this, although this is my speculation, was that they're trying to balance that barrier to entry. So they're saying, look, it's very easy to file an application, but if you file an application, you're going to have to provide something more than that 51% certainty, right? What we're saying is it's going to require a little more evidence. The problem is, again, what exactly, how you define that. More than 51%. If you use clear and convincing, if you use substantially more likely than not, I've seen that as a more plain language formulation of clear and convincing evidence, et cetera. As a lawyer type, I do like the idea of having a legal standard insofar as if a discharge is provided and the institution is then engaging with the department in front of an administrative law judge over recovery, I believe an ALJ will understand what clear and convincing means, very much in a traditional legal sense. But there are many negotiators at the table, too, who have sort of a general aversion to even using legal concepts because they feel like it will be hard to understand for borrowers and persons who are not attorneys. So lots and lots of debate around this. I believe that we're probably going to see something from the department that attempts to define clear and convincing, but maybe in plainer terms in the next set of draft regs. And I should say we do expect to see another round of draft regs in advance of the third session. So let's break down and talk a little more about judgment of the court, judgment of an arbitrator or administrative tribunal, and BDR misrepresentation. So the judgment of a court is what it sounds like. The borrower has to have obtained from a court of competent jurisdiction a non-default contested state or federal judgment. So in other words, someone has to show up and have contested it, right? You can't get an uncontested judgment. This would have to be contested, and the borrower would have to have been awarded monetary damages, right? There wasn't a lot of debate around this. There were those who felt like it shouldn't have to be contested, but I think there wasn't, as a general matter, a lot of debate over this idea of a judgment from a court of competent jurisdiction serving as a basis for claim. This was new. The department also introduced the idea of a judgment of an arbitrator or a tribunal. Borrower must have obtained from an arbitrator or a hearing official in a state or federal administrative tribunal agreed to by the borrower and the institution a non-defaulted contested judgment or equivalent final determination and have been awarded monetary damages. You see I've put in red because this is an important point, this agreed to by the borrower and the institution. So we're not talking about administrative processes to which an institution may not have agreed. Right. What I think the department is really getting at here is institutions, at least some institutions, have expressed a desire to be able to manage disputes with students through arbitration. Right. I mean, that's the genesis of the pre-dispute arbitration agreement. And I think what the department is saying is, okay, look, this time around, as opposed to last year in 2016, this time around the department is not attempting to ban institutions of higher education from using pre-dispute arbitration agreements. Right? Let me make that clear. That's been very clearly stated by the department. They are not attempting to prohibit institutions from using pre-dispute arbitration agreements and enrollment agreements or other contracts with students, right? But what the department is suggesting here is, look, if you and the student have agreed to work out your dispute in front of an arbitrator, right, and then the arbitrator comes up with a judgment, then the student should be able to use that judgment. I mean, you guys agreed to that process. Similarly, if a borrower and an institution agreed to a process to resolve their dispute with an administrative tribunal, the department is saying that that judgment ought to hold water. I think that this idea of a state and federal administrative tribunal is worthy of further examination, and we'll hope to get a little more clarity from the department on this if it's still in the next draft. But it's an important point that we're drawing a distinction here between potentially agency actions that may be brought by some outside agency against an institution. That's not what we're talking about. What we're talking about here is a process to which the borrower and institution have agreed. Again, though, maybe room for some additional clarity on that point in this language. Also, there's still the requirement that monetary damages have to be awarded. But the big innovation here, and what really, not surprisingly, caused the most conversation was this third concept, and that's the new federal BDR misrepresentation standard that the department has floated. So this would be a federal law in the Department of Education's regs that gets at misrepresentation specifically for purposes of bringing BDR claims. And this is what the department has proposed. The institution, and remember, this is a claim that the borrower is bringing that has to relate to the loan or the provision of educational services. But in addition to that, the borrower would have to demonstrate with clear and convincing evidence that the institution at which the borrower enrolled acted with an intent to deceive, knowledge of the falsity of a misrepresentation, or a reckless disregard for the truth in making a misrepresentation of material fact, opinion, intention, or law upon which the borrower reasonably relied in deciding to obtain a direct loan to enroll or continue enrollment in a program at the institution and which resulted in financial harm to the borrower. So this has a lot of elements that you would see in different UDEP or misrepresentation or fraud standards around the country, right? And the department, in some cases, they're not taking the most aggressive stance, and in other cases, I think they are taking a standard that is certainly higher than what we saw in 2016. And my impression is that they are doing this in an attempt to find a middle ground, right? So the first thing to note right out of the bat is we have a standard of intent to deceive, knowledge of the falsity of a misrepresentation, or reckless disregard for the truth. Now, it was offered a number of times and sort of characterized a number of times during the negotiation as an intent to deceive standard. I want to be very clear, at least to my constituency, that that's not what this is, right? Intent to deceive is one option, but this is a disjunctive sentence, right? And knowledge of the falsity of a misrepresentation or a reckless disregard for the truth is a lower standard. So to be clear, a borrower does not have to establish that the institution had intent to deceive. If a borrower did, that would be a basis for a claim, provided these other elements are satisfied. But it is possible to bring a claim if a borrower can establish knowledge of the falsity of a misrepresentation or reckless disregard for the truth, right? And there have been various different proposed revisions. One individual proposed taking out reckless and just saying or a disregard for the truth. There was some debate over whether these concepts were too legalistic and there should be something that's a little more plain language and which way it should go. But again, the department seems to be proposing a standard here that in my view is somewhat of a middle ground, right? Understanding you've got a low barrier to entry for borrowers to file these applications. And in this case, it's not a full-on intent to deceive standard. There is a possibility for a borrower to bring the claim if, for example, they can establish reckless disregard for the truth. The representation or misrepresentation has to be of a material fact, opinion, intention, or law. So that's important. There is a materiality standard here upon which the borrower reasonably relied. So there's also a reasonability standard. There were folks there who strongly argued that that should be modified to say borrower reasonably relied under the circumstances. And I think part of the idea there is sometimes you have borrowers at differing levels of sophistication, and the proposal of that language was to try to accommodate that. Rather than having sort of the single reasonable person standard, it should really be that individual under their circumstances was acting reasonable. And I think that idea got some traction, and you may see that revision in the next round. And then finally, there has to be a showing of financial harm. And there's a lot of discussion, and we'll get into it in a few minutes here on what exactly that means, and the department has attempted to offer up some definitions. So this is the actual definition of a misrepresentation. So I'm going to go back to the prior slide. You'll note that, misrepresentation here is not actually defined. So this is the standard, intent to deceive, knowledge of the falsity of a misrepresentation or a reckless disregard for the truth. But the department also wanted to actually offer up, in this context of a borrower defense proceeding, what they mean by misrepresentation. This is what they suggested. A misrepresentation is a statement, act, or omission by an institution that would mislead a reasonable person. So again, they've inserted this reasonable person concept. And again, there are folks who felt strongly that that should be reasonable person under the circumstances, regarding the nature of the educational program, the nature of financial charges, the employability of graduates of an educational program, the eligibility of the educational program for licensure or certification, the state agency authorization or approval of the educational program, or an accreditor approval of an institution or educational program. So the value here is, you know, I spoke earlier about a concern I had that the concept of educational services is so broad, but the department is, in other ways, I think, is in fact helping to put some boxes around this. I mean, in the regs, they've articulated, in some instances, types of claims that would clearly be outside of a bar defense claim, and we mentioned earlier a discrimination, violation of civil rights laws, tort claims, things like that. And here again, I think they're trying to draw a little bit of a box and saying, look, a misrepresentation for the purposes of a bar defense claim isn't just anything. It's a statement, act, or omission that would mislead a reasonable person regarding these types of things. I say these types, you know, the department has offered up this list. It is presented in a way that seems exhaustive, but I would certainly, as an attorney type who represents institutions, my guess is if you had something that came up that didn't fit exactly into one of these buckets, but was very similar, there would be a likelihood that the department would take the view that it also constituted misrepresentation. It can be really difficult, you know, to argue that something like this is exhaustive and not illustrative, and I think the department might take the view that this is illustrative, even though the wording doesn't necessarily suggest that. They also have offered the department and the regulations evidence of misrepresentations. So they have this general lead-in language that was on the prior slide saying, you know, this is what a misrepresentation is. And then they say evidence of a misrepresentation could include, and they give these very specific examples. In most cases, and I've got them here, there is a catch-all, though, that I don't include here. So at the end of this list, I don't have a box for the catch-all, but please be aware that the department does have this catch-all phrase that sort of says, and any other, you know, evidence that we think is appropriate. But they do give these, in this case, an illustrative list for certain, examples of the type of evidence. And in every case, it's more or less if there is a material difference between the representations that were made to the borrower, I say students, but to the borrower, and the actual circumstances in the following categories. So with regard to licensure passage rates, job placement rates, specialized programmatic or institutional certifications, transferability of credits, employability or earnings, availability, amount, or nature of financial assistance, tuition and fee amounts, endorsements or prerequisites. I shoved those into one box. They were actually two different line items. So endorsements, and then you can sort of think separately, prerequisites. Institutional size, location, facilities, training, equipment, or faculty qualifications. Now, of course, the department, I did not include the full regulatory language here, and each one of these has its own line, and there are some nuances in that language. And the negotiated rulemaking group, we went through every one of those, and people highlighted various issues. For example, a number of the financial aid negotiators were uncomfortable with the idea of the availability, amount, or nature of financial assistance. And the point was made to the department, and I think the department understood this, but realized there might be room for improving the language. The point was made that, you know, often students before enrollment will come to a school and you give them, based on fairly limited information, projections as to the type of financial aid that will be available to them. You might do what's called a tuition proposal or some sort of mock-up for an award letter, a preliminary award letter. And after they enroll and more information, tax records, et cetera, are obtained, they may actually end up with an award package that looks potentially materially different. The other thing that obviously can happen is you could put together a proposal for someone prior to enrollment, and in the interim, they might secure an outside source of funding, a scholarship, or, you know, Uncle Jim may just decide to give them $10,000, and that may also cause a material difference in the availability or amount or nature of financial assistance they ultimately end up with. So those types of conversations were had, and I don't want to suggest otherwise. I mean, we went through every one of these in detail and highlighted concerns and issues, and folks from every, representing all the different constituencies, sounded off on all of those things. But what I really want you to understand here, just as we're going through what the department has proposed, is that you've got this new definition of misrepresentation, and the department has actually offered up several buckets, looks to be about 10, 11 different buckets of what they would consider evidence of a misrepresentation. Now remember, you still go back to that standard. So a student would still have to establish through clear and convincing evidence, right, that they reasonably relied on this misrepresentation and that the institution either intended to deceive or had knowledge of the falsity of the misrepresentation or was acting with reckless disregard when it made it. and that it resulted in financial harm to the student, right? So just because you have what might constitute evidence of a misrepresentation under one of these things does not necessarily mean you have a successful bar defense claim. And this goes back, again, to the point I made at the outset, which is all this stuff hangs together, and you can see how it becomes problematic if you start just arguing over, you know, employability or earnings and what might constitute a material difference with regard to employability or earnings, and you're not thinking about, you know, this as it relates to the misrepresentation definition as a whole and how that fits into the standard and how that fits into the whole bar defense framework. Financial harm defined. One of the other things I noted was, you know, under the standard, a borrower has to establish that they incurred some sort of financial harm. And so the department has made an effort in the regulations to define what financial harm does or does not mean. And again, and you'll see on my next slide, to give some examples. So this is the regulatory language, amended just a little bit to fit on the slide. Financial harm to the borrower has occurred when the borrower suffers monetary loss as a consequence of a misrepresentation or is found by a court, arbitrator, or hearing official. Financial harm does not include damages for non-monetary loss, such as inconvenience, aggravation, emotional distress, pain and suffering, punitive damages, or opportunity costs. Financial harm is such monetary loss that is not predominantly due to intervening local, regional, or national economic or labor market conditions. So there was a lot of discussion around this concept as well, and I think we'll probably see some revised language from the department. There were those who felt that the fact that a student took out a loan and the loan debt itself should represent financial harm. I think the point that was made in response to that argument was, well, the student and the institution have negotiated or, quote, bargained for an exchange of tuition and fees for the education provided. And if the education was provided and the tuition and fees were received, the question then becomes, and then there was a misrepresentation in the mix. The question becomes, did that misrepresentation cause some sort of financial harm apart from that bargain, right? Because insofar as the education was delivered and the tuition fees were paid, I mean, that was the bargain that was struck, putting it in very, you know, sort of cold terms, contractual terms. You know, there were some who weren't persuaded by that argument, I'll just put it that way. So there was a lot of back and forth. There were folks who felt strongly that opportunity costs should not be excluded. I think the department, again, I'm speculating, but I think part of the concern there is trying to quantify opportunity costs in any way becomes extremely difficult. There was some discussion over the carve-out for financial harm due to intervening local, regional, or national economic or labor market conditions. I mean, for institutional representatives and risk managers, this just seems, I think, sort of common sense and absolutely essential. But the point was raised by others as to, you know, would this be an out for folks? Or would they somehow try to show that there was no financial harm by hanging it on local, regional, or national market conditions? So a lot of back and forth here, a lot of differing views, but I think it's very helpful to see at least where the department came out on this initially and what their thinking was. And there is a sense, importantly, that an individual should have to establish some financial harm. That's also consistent, and I know some lawyers and others out there who deal with UDEP standards and similar standards. It's not uncommon that there has to be some showing of substantial harm. Right. One thing I would add that the department has not required here, apart from inserting a reasonable person standard, the department has not required individuals to demonstrate or borrowers to demonstrate that they've done anything to mitigate the damage. And as many who deal with these types of standards know, there are certain standards, including the FTC standard, that require or take into account whether or not the individual harm did anything to mitigate the damage that was experienced, for example. So, you know, again, I think the department is trying to find its way to the middle of these various types of standards that are out there. But as you would imagine, different negotiators are inclined to push the department towards a more conservative or a more liberal point of view. I mentioned that they also the department has attempted to articulate actual evidence of financial harm. And you know, I think these are requiring a lot of additional thought. Again, the negotiators went through each of these in great detail, but I'll give you an idea of what the department's thinking here. And this represents conceptually each of the buckets, although I did not include all of the detail in the reg itself. Significant difference between the borrower's earnings and marketed earnings. a significant difference between the borrower's earnings and public earnings data, lower or lost wages, extended periods of involuntary employment, cost of obtaining non-transferable credits, significant difference between tuition and fees charged and borrower's reasonable expectations, inability to obtain employment when it was expressly guaranteed. Now look, on this last one, if you were expressly guaranteeing your students that they will be employed prior to graduation, you should call me. I'll just put that to the side. You should give me a call and we should talk about that. But the rest caused some eyebrows to raise, particularly from the institutional representatives at the table, because I could see when folks first read this, their concern, you know, at this idea or notion that, for example, if someone could demonstrate a significant difference between their earnings and public data saying what kind of earnings someone in that type of position should make, that would in and of itself represent financial harm and give rise to a bar defense claim, and that was a problem. I want to make an important point here, a couple of important points. The first is I do think there's a lot of work to be done on these various concepts. I want to make that very clear. But the other thing that's important to understand is demonstration of financial harm or incurring financial harm as defined in these boxes does not necessarily give rise to a bar defense claim, right? In fact, under these, if you are a graduate of Harvard Law School, for example, right, and you decide to go work for a public defender's office or return back to your hometown and open your own practice, it is absolutely possible that you will experience financial harm, right? Not because the institution has failed to deliver, but because you graduated from an elite law school where graduates, and my guess is publicly available data shows that individuals typically make a fair wage after graduation. And you've made a deliberate decision to go a path that is resulting in a far lower wage, with the result that you have probably inflicted significant financial harm upon yourself, right? There's probably a significant difference between what you're earning and what the law school may have said their typical graduate earns, or what public data may say a typical attorney makes, right? But the fact that you've endured financial harm or financial harm has occurred under one of these definitions does not in and of itself give rise to a bar defense claim. Remember, you got to go back to the beginning. There has to be a nexus, a clear and convincing nexus between the act or omission of the institution and the financial harm. In other words, the borrower has to demonstrate, one, let's just recall that you either acted with the, meaning an institution, acted with the intent to deceive, falsity of the knowledge of the misrepresentation, or reckless disregard, and that you made a material misrepresentation, right, clear and convincing evidence that you made a material misrepresentation, and that as a consequence of that material misrepresentation that you knowingly made, the individual experienced financial harm. So there's a lot that hangs in with there and works together. It's not just the definition of financial harm. Really what the department is trying to do here is to sort of figure out some way to quantify whether someone in fact incurred some sort of financial damage, right? And they're expressing different ways that that measure might be made, or you might reach that quantification. Again, I completely agree, and I don't want anyone to think otherwise, that these concepts require further consideration and that there are changes that could be made, and we went through every one of these as negotiators. But one thing I did want to make very clear is that the sheer fact that a borrower incurred financial harm in and of itself does not give rise to a bar defense claim, right? I mean, there's a whole mechanic there, and this is one piece of that mechanic, right? All these other things also have to be demonstrated in truth. So it's just important to keep that in mind and how all of this works together. All right, the borrower defense. So the department also articulated various types of evidence that an institution could provide in order to rebut the borrower defense claim, right? So maybe the better way to say this would be the borrower defense rebut, but it's not as cute, so I went with borrower defense. Institutions can provide evidence rebutting BDR claims, including, and the department gives you 4 examples in the regulation. 1, for a claim based on licensure exam passage rates, that the program has a passage rate that reasonably approximates the passage rates represented, right? For a claim based on the inability of the borrower to obtain a certification or licensure needed for employment, the borrower has obtained a certification or licensure related to the program without needing additional coursework. So in other words, what the department is saying here is a borrower is saying, you know what, I needed a particular certification or licensure in order to get employment, right? And what the school is showing is, well, there was a certification or licensure that that the individual was able to get that permitted them to obtain employment, and they were able to get that without doing anything additional, right? These are probably of more significance, though, and these were the two that garnered much more discussion during the negotiated rulemaking. The institution can provide information to the borrower to correct the misrepresentation prior to the borrower enrolling in the program. So that all has to happen pre-enrollment, but the department is allowing here essentially for the institution to cure the misrepresentation, right? And that's an important concept and an important opportunity for institutions. And this final one, as you will guess, garnered the most attention. The institution demonstrated that its representative or agent made a misrepresentation that was inconsistent with or prohibited by the institution's policies, procedures, and training at the time it was made. So this is the bad actor carve-out, right? And I should say, by the way, establishing one of these things or providing evidence of one of these things does not mean that you automatically will have your you'll win the day and the borrower defense claim won't be successful. What the department is saying is this is evidence you can provide in an effort to rebut. But it's important that the department has clearly signaled its understanding that sometimes there are bad actors. And it is essentially opening the door for and inviting institutions to demonstrate that there may have been a bad actor involved and that the conduct was not representative of the institution at all. There were a lot of suggestions made. As you would imagine, there were folks among those who represent borrower interests who felt like that this was a get-out-of-jail-free card type provision. There were folks representing institutions and on the other side of the conversation that said, okay, but look, this is a really important concept and this does happen. You know, you have a large institution, and somebody asked me if I have some affiliation with Ohio State because I kept using them as an example. I'm not picking on Ohio State. I just use them as the example of the massive institution. I mean, you have an institution with tens of thousands of employees. Look, there are knuckleheads out there. And there ought to be some opportunity for an institution to say, this was a knucklehead doing something on their own that has nothing to do with us and certainly does not represent the way that we do business. In fact, our policies and procedures specifically prohibit that conduct. And institutional representatives said, look, we need the ability. This is an important concept. So there were revisions to this language that were offered up. Folks suggested maybe that institutions should have to demonstrate that they were enforcing those policies and procedures. So you can't just say we've got it on the books. That they enforced it specifically against that bad actor, that this isn't some sort of widespread or systemic conduct. So in other words, there's a difference between a representative of the institution that makes a single misrepresentation and one that has made that representation to 3,000 students, right? So there were efforts to workshop this language, but even with those efforts and modifications, the concept remained, and I expect it to remain, and I think that's very important for institutions, and was personally pleased as a representative of the risk managers to see this here. Statute of limitations, this is a really important sort of final piece on all of this. The department has said that borrowers must file a claim within 3 years of the date the borrower discovered or reasonably should have discovered the misrepresentation. So in the 2016 negotiated rulemaking, there were a variety of different statute of limitations, and they moved depending on the type of underlying claim. It is my view that while it is possible, you know, if a borrower can demonstrate that they could not or should not have discovered something until, say, 10 years after the act or omission, I mean, that could mean that this extends far beyond 3 years, right? But as I think it more practically will be the case that frequently the 3 years will be operative or something very close to 3 years. And that's an important piece for institutions. There's no time limitation on recovery actions. So the department, once that borrower defense discharge has been considered and granted, the department reserves the right essentially under these draft regulations to bring that action at any point. You know, my argument to the department, because I jumped on this pretty readily, was that it's one thing when you're talking about a borrower perhaps not having the information or the wherewithal to know that a misrepresentation had occurred, right? So you have this allowance for when the borrower could reasonably or should reasonably have discovered that act or omission. But there is no reason that the federal government should not know when a borrower discharge has been granted, right? I mean, the department is the one executing on the discharge. It's going to know the day that it happens. Why should there not be some sort of reasonable recovery period so that institutions can have some sort of ability to mitigate their risk. The other thing, and this is really one of the underlying bases for statute of limitations in general, is, you know, the longer you get out from the act or omission occurring, the staler the evidence becomes for both parties, and it makes it harder for justice, right? I mean, the idea is you want things to be resolved timely so that everybody involved can be best prepared to advance their position. So we argued that the department should put some sort of cap on this. I mean, said, you know, we get you don't want to leave the taxpayers out to dry, but surely the department has the wherewithal to determine whether or not it's going to try to recover from an institution and to initiate that process within 2 or 3 years of discharging the claim, right? I'm very hopeful. That seemed to resonate, and I'm hopeful that we will see some sort of statute of limitation put on the recovery actions. Although the department noted they are very reluctant to hem themselves in, and that won't surprise anybody. So the draft claims process. Oh, by the way, there's your secret word number 3, REX. It's your 3rd secret word. You're welcome to email me if you know the significance of these 3 words. I don't have any prize for you, but happy to give you a congratulations. So the claim process, there was less conversation about this and dispute, and it's because the department, it is my personal view, again, that the 2016 process that was laid out was not fair to both parties. The department has tried very hard this time around, I think, to design a process that treats each party more or less equally. And the negotiators at the table seem to be comfortable with the idea that a process that gave both parties equal rights was essentially a fair process, right? I mean, what the institutional reps and the folks representing borrowers didn't want is for their side to be disadvantaged. So I think, and I'm pleased to say, I think that we've got a process here that works fairly well, and also there were some really good ideas that were put out there, one I'll hit on later, and that we may end up getting, again, we have to get consensus on the entire rule for the department to be bound, but I think if the parties can achieve sort of a sub-consensus on process, the department would likely adopt the process that they agreed to, and this process isn't terrible. That's not exactly praise, isn't terrible, but, you know, it's a little better than isn't terrible. It's working towards fairly decent. So the borrower submits a claim application. So again, no prerequisite that the department has initiated a recovery against the borrower. The department grants forbearance, suspends collection activity, and then the department qualifies the claim. You notice, if you saw one of my earlier presentations in 2016, I was very clear about saying that staff qualifies. Staff does this, staff does that. This administration has been careful to say the secretary. Now, I believe they're still talking about staff. There is no indication to me that we're talking about these going in front of an administrative law judge. And I have on the record at both sessions stated that I think everything should be done in front of an administrative law judge, or at least the most independent component of the department that we can find, and I've articulated a bunch of reasons for that. If you want to know, call me or send me an email. I'm happy to tell you. I won't bore you here. But it seems, again, that the train has left the station and that most negotiators in the department are committed to a bifurcated process. And what I mean by that is one process that adjudicates the discharge and a secondary recovery action against an institution, right? So what you're looking at here, but for the last box in red, is the first part of the process by which the discharge determination is made. And if there is a discharge determination, then the box in red represents part 2, which is the recovery action. Okay, so, but one thing I like is that the department has indicated that it will at least include a step where it qualifies the claim, which I understand to mean someone's going to look at this thing and see if on its face it even alleges, even if you assume everything is true, a complete and viable claim. If it's qualified, then within 60 days the department will send a claim and application, sends the claim along with the application and the supporting evidence to the school and provides the school an opportunity to respond, guaranteed in the reg. The department will then review the evidence, the department's records, the school submission, and then it says, and it may review any other relevant evidence. And some folks said, well, why is that a may? And the department said, look, if we've got relevant evidence from a qualified source, we might use it. If it's from a source that we don't consider qualified, we may not use it. And they were very careful to reserve that flexibility, and I think that was wise. And then ultimately the staff issues a written decision to the borrower and the school. Now, a lot of suggestions were made to improve this process, among them that the department make sure that both parties get the evidence that has been supplied by both parties and have an opportunity to speak to that evidence,
Both parties should have an opportunity, they should certainly both receive the written feedback. There should be a guaranteed time frame within which they have to respond. And again, most of these suggestions, because they were suggestions that would afford equal opportunity to both parties, were generally seen to be met with amenability from the department, and I think that's really positive. So I think we're working towards at least a pretty good process, setting aside the argument over whether the process should be bifurcated or a single process. The other thing that's been proposed, and I have this on a later slide, but I'll mention it now, and I'll just give a shout out to one of the negotiators, Chris DeLuca, who made this proposal. He suggested that the department should consider an early resolution process similar to that used by the Office of Civil Rights. And the idea would be that on the front end, as soon as a claim is made, but before the department qualifies it and initiates this process, that there should be an individual at the department who reaches out to the parties and to see if they can reach an informal resolution. Both sides seem to think that this would be a good idea. I mean, our view was, when we're talking about institutions that are good actors, where something has come up, in most cases, we thought that institutions would appreciate an opportunity to work with the student and see if they could resolve something informally before getting into a process where they're going to have to call up their general counsel or their outside attorney and, get into the weeds with everything, right? And I think that the consumer advocates, again, this is just my observation, I'm not speaking for them, but my observation was that this seemed amenable to them because one of the big concerns I'm hearing from the consumer folks representing consumer advocates is you've got unsophisticated borrowers who may not have legal representation, who really don't know how to navigate these processes. And they're filing a claim, even though it's a low barrier to entry, all you have to do is file an application, they may not still understand much about what's going on. And the idea in the early complaint resolution process is that you've got some individual from the department who may not be, who's not advocating on behalf of either party, but can serve to explain concepts and help facilitate resolution, which could be a significant benefit to a borrower that potentially lacks sophistication, because now you've got someone from the department who can sort of say, well, these are the issues, and these are the options they're proposing, et cetera. And they're not just out there on their own trying to deal with the school, for example. Because another idea that was floated was, well, should we require borrowers to have to connect with schools in advance so that they have the opportunity to resolve issues? And then there was this concern about predatory schools taking advantage of borrowers. The early complaint resolution process it seems to be potentially a very happy middle ground. That could be a very positive concept for both sides, sides meaning institutions and borrowers in this case, and could help to dissuade frivolous claims and also resolve one-offs for institutions. So I'm enthusiastic. The department originally had some concern about costing, but one of the points that was made was that it would probably cost them a lot less to facilitate resolving things informally than to require departmental staff and then an administrative law judge and an attorney on the back end trying to recover from a school to go through all those machinations. And the department seemed to, that seemed to resonate. So I'm very hopeful that in our next draft we may see something like an early complaint resolution process, and it is my personal belief that that could really be positive for everyone involved. If it isn't resolved, though, and it does go through and there is a discharge, then the last thing that happens is the department then decides if they want to recover from the school. I mentioned earlier they seem to have an intention to do so. They've stated that they do, and that would be carried out under Subpart G, specifically 34 CFR 668.87, and that's the regs that went into effect in January that are already in effect. Okay. Just a quick note on reconsideration. Within 60 days, either party, the department would propose that either party can request reconsideration based on newly discovered evidence. There was some discussion over what newly discovered evidence means and whether that's appropriate. But I think from the institutional standpoint, there was an appreciation that both sides had an opportunity to potentially do this, whereas in 2016 it was sort of a one-sided opportunity for borrowers. All right, some additional thoughts on the standard and on the process. I just want to highlight a few things that aren't here. There's no breach of contract as a basis for a claim, which was around in 2016. There is no group claim process, right? So this entire idea of the department initiating unilaterally a process absent underlying bar defense claims is not here, and that is a very significant omission from the institutional viewpoint, I believe. Relief, there's no mechanism for the department to, you remember I mentioned in 2016 there was a whole section in the regs where they tried to talk about how they would calculate partial relief. Here the department has taken the view that this is up to their discretion. And then again, I mentioned that this early claim resolution process has been proposed, which I think is very advantageous. I just wanted to comment briefly on the other topics on the table. I know we're at the 90-minute mark. I'll make this quick. On financial responsibility, the department is not proposing automatic triggers as was done in 2016. So there's no event or action that would automatically result in a school having to post some form of surety. What the department is proposing, though, is that there is a new short list of additional actions or events that, if they occurred, would have to be reported and could result in one case to a recalculated composite score or otherwise require an institution to have to post some form of surety. It's a short list, and I've given you those items here. We, the negotiators for institutions and risk managers, are working to improve the procedural safeguards to make sure that if one of these events or actions occurs, institutions have ample opportunity to dialogue with the department. It is my view that that has been missing and is missing from current law, that where you have some sort of financial responsibility concern, there's not a guaranteed opportunity for institutions to try to dialogue with the department and show why some action or event may not represent financial risk for that particular school. Finally, the department's also proposing to expand the types of sureties that it would take beyond a letter of credit, and I consider that extremely positive. On pre-dispute arbitration class action waivers, the department does not attempt, and I said this earlier, to prohibit pre-dispute arbitration and class action waivers from agreements with students, and in fact has clearly stated that it's consulted with the Department of Justice and does not believe it has a legal authority to do so. It does propose enhanced disclosures for schools that are using those kinds of waivers, potentially during the exit and enrollment loan counseling process and at other points. What's interesting is nobody seemed to like that idea. The consumer advocates seem to think that that was wasted, I'm not saying that they have suggested it should go away, but I'll just say no one on either side of the table or among servicers, anyone seemed to think that additional paper thrown at students was going to be particularly productive. So we'll have to see. It'll be very interesting to see if this goes away entirely or if it's somehow augmented. For closed school discharge, the only real modification is that the department wants to extend the period in the regulations for folks who are eligible for a closed loan discharge from 120 back to 150 days. There were those advocating a much longer period. I think the department's probably going to settle on 150 days. I will also note there were those of us who were also strongly advocating a shorter period and or suggesting, and this is a personal belief of mine, that there are serious mechanical issues with the way closed school loan discharge is both in the law and as a practical matter handled right now. I think it creates a lot of perverse incentives for students and institutions alike to act in ways that we don't want them to act when you have an institution or additional location closing. Very important for folks to appreciate that this all applies even if you're pulling an additional location off your e-car, not just if the whole institution is closing. So the department's not proposing many changes to the current law. I suspect all you're really going to see is a change from 120 to 150 in terms of material changes, although I am arguing that more changes should be made. I'm probably alone in the wilderness on that one. False certification discharge, the only real material change. I mean, you're welcome to go look at all the proposed changes, and I suspect there will be more. I don't mean to suggest that this is the only thing out there, but in the interest of time, I'm trying to curate and bring to your attention the things I think are most significant. Under false certification discharge, it would extend false certification to instances in which an institution knowingly certified a loan for a student who did not have a high school diploma or its equivalent. But that knowing knowledge concept, you know, is there, and it's very important, and we will make sure to do everything we can to acknowledge that it needs to stay there. The subcommittee on financial responsibility, I'll just offer really quickly. For the most part, and the group, by the way, is doing this. This subcommittee is, I mean, they're all just luminaries and real experts and clearly very knowledgeable about what they're doing, and I think did a really good job reporting back to the full committee. I am not a CPA. I spent some time talking with them and with some CPAs in the industry. Chris DeLuca, who is one of the alternate negotiators, is a CPA, and he had a lot to say on this and was thinking very thoughtfully about it. From my standpoint, and what I'll communicate to those of you particularly who are not CPAs, who like me find some of that difficult to track, this is what I'll say. Most of this exercise is about updating the terminology used in the composite score, not about changing the way the composite score works, right? But updating the terminology and revising the composite scores simply so that it can accommodate changes in the accounting rules and FASB standards that have already occurred. The primary issue, from what I can tell, revolves around the treatment of leases, which, you know, historically have been off the balance sheet, right? So now leases are going to be, because of the change in the accounting rule, would be categorized as long-term debt in the composite score, which if you recalculate your composite score tomorrow, depending on where you are in certain leases, it could cause a drop in your composite score. And they did some stress testing and talked with other folks and felt like that could go anywhere from, you know, 0.1 or 0.2 to 0.4 or 0.5 or even a 0.6 type change. So, you know, someone could go theoretically from a 2 to like a 1.4 in a worst case scenario. Okay. So the rule has changed, and the department does not control the rule. What the department controls is how soon it changes the composite score and acknowledges that change in the rule, right? I mean, they can't stop the fact that this is how things have to be treated by your accountants, but they can change the transition period. And so what was proposed was a 4-year transition period, and during that period, the department would calculate 2 composite scores, right? They would calculate one using the original methodology with regard to leases and one treating the leases under the new rule. And you would get the benefit of whichever one is better. And at the end of that period, they would start only calculating a composite score, treating leases the way they now need to be treated, at which point institutions would have to move forward with that treatment. So the concern was that if you look at the time frame from when the rule changed with the accounting rule and when the proposed transition period would occur, it is possible that some institutions, for-profit, non-profit alike, that may have very recently signed leases could still be hurt. And so most of the discussion seems to be around whether or not the department would consider either extending that transition period or having some sort of secondary transition period for what will likely be a subset, a smaller group of schools, but schools that could be impacted for no other reason than that they had the bad luck to sign a lease right at a 10-year lease, for example, right at the time the accounting rules changed. So we're pushing for that. I mean, I spoke to that. Chris DeLuca and others spoke to that. I think the subcommittee is going back and looking at it and considering whether there might be some way to do a broader transition period. And I think the department's generally amenable to considering those concerns. So that you know, I just did not want you to think that that is being ignored. It's a very important issue, and we are working through it. Okay. And that's pretty much it. Here's our blog. The last session, so on the left is the actual negotiated rulemaking session. The last one is the week of February 21st. And then we'll be doing, oh, I'm sorry, I misspoke. The last session is on the right. So the session occurs February 12th through the 15th, and then we'll have our last webinar in which I'll sort of sum up and report on all 3 sessions and whatever the last version of the draft language was. That'll be on February 21st. So with all of that being said, let me see if I can get to some of the questions, and I do think we have a few. Let's see. Can you give a few more examples of education malpractice that would not be covered by BDR? We get a lot of their classes weren't good. I didn't learn anything to prepare me to get a job. Is that included in BDR or not? Thanks. So my view would be, I mean, the traditional notion of an education malpractice claim. By the way, let me step back and say, early last year, a partner of mine did a three-part series on our blog on educational malpractice, so, and some of the recent case law surrounding educational malpractice. So if you have an interest, it's still on the blog. You're very welcome to go out there and take a look at it. She's a litigator and knows more about it than I do. But I can tell you, traditionally an educational malpractice claim, it's exactly what you've more or less characterized. It's someone saying, you know what, they didn't do what they said they were going to do insofar as the quality of the education I received, right, wasn't any good. I didn't learn the stuff that they said I was going to learn, or, you know, but it's not even, I guess the important distinction to draw is this one. Education malpractice claims really aren't based on representations that were made. So the argument is not that there was a misrepresentation, either in writing or orally, with regard to what you were going to do, right? So if you said, we are going to provide you with, you know, a bachelor's degree, and then you gave the student an associate degree, they would not, that's not a malpractice claim. They would, I assume, if their attorney is any good, would bring a claim based on misrepresentation, probably under a consumer protection statute or something like that, right? So I guess in my mind, the real distinction is we're not talking about a student saying, you represented X to me. and X turned out not to be true, either in contract or whatever, right? It's not a misrepresentation claim, and that's really the fundamental concept underlying BDR, right? If you look at the standard that the department's come up with, I mean, it's really it's like a unfair deceptive trade practices type standard or a misrepresentation or fraud standard. You said something that wasn't true to me. Education malpractice is just about, you know, the education wasn't any good, right? You did everything you said you were going to do, but it just wasn't any good. The teacher wasn't any good. I didn't learn anything. You know, I didn't like the program. That kind of thing. It's a more general claim about the quality of the education that was delivered. It's not a claim that some specific representation you made was not true. But again, you can see even in the sort of my struggle to articulate that how the two could get close or conflated. Or someone could say both, right? I mean, someone could say, you told me X, Y, and Z were going to be true, and those things weren't true, and also I didn't learn anything. And then someone is potentially stating both. They're bringing both a misrepresentation claim and an education malpractice claim. I mean, if you were in court, you know, you would have to articulate what laws you're claiming were broken. But if someone's just filling out an application to the department, it could get a little conflated. And so I think what the department was acknowledging is they're going to have to do some discriminating there and trying to figure out whether, you know, but that's that qualifying the claim step in my mind. You know, when you're looking at this and you're saying, is this just a straight up education malpractice claim? If it is, we're taking it off the table. If there are multiple allegations, and some of them really are misrepresentation style allegations, even if there are others that are ed malpractice, what we're going to really focus on here, we're going to disregard the ed malpractice, but we would move forward. This is the department saying this. I think the department, their point was we would move forward with the misrepresentation claim. Great question. I hope that was helpful. Would loan servicers no longer be part of the individual claim process? During the Corinthian debacle, the department said students had to file their claim directly with the servicer, and the servicer would decide and submit their decision for approval by the department. I mean, there are servicers at the table, by the way, and I assume if the department were openly suggesting that they were going to be completely excluded, we would have heard from them. And I have not heard the department say this, but, you know, I don't think the mechanics of who is facilitating or servicing the applications are really contemplated in the regulation, right? I mean, loan servicers aren't going to be adjudicating the claims, but whether or not they would facilitate getting applications to folks or facilitate getting information back and forth or distributing certain things to parties, I don't know. As you all know, loan servicers have been assisting with lots of different kinds of things over the last 5 or 6 years, and many of them were apart from anything they had done before, but the department has sort of used them for various different functions. So, you know, I guess the answer to the question is I've not heard the department take a position on whether or not servicers would be involved at some level in processing these claims. The servicers certainly aren't responsible for making the actual determination with regard to qualifying a claim or whether or not the claim is valid or not. At least the regulation says the secretary. So it clearly does not contemplate servicers expressly. I guess that's, you know, there's some question as to whether or not, at least for purposes of accepting applications and maybe qualifying claims, the secretary might try to outsource that to loan servicers. I guess that's conceivable. Harder for me to imagine that the loan servicers would actually be adjudicating the claims and reviewing evidence and making a determination. But again, I haven't heard any specific conversation to that point. Thank you all so much for tuning in. As always, deeply appreciated. The next session I mentioned earlier is about middle of February, and so our next webinar at the end of February, I'll be wrapping the whole thing up and hopefully giving you a pretty solid idea of what the last version of the regulations from the department look like, and what I think may happen with the proposed rule. All right, everybody, have a great afternoon.